Good morning. Are you Avriana Dorsey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, sir.
Ms. Dorsey, in cause number 26, DCCR 0756, you're charged with a first-degree felony. You guys marked off second, but is it a first?
It is a first, Judge,
With y'all's permission, can I change that
Yes, ma'am.
admonishment?
because it's burglary with
Intent.
the aggravated assault.
So you're charged, Ms. Dorsey, with a first-degree felony offense of burglary of a habitation with the intent to commit another felony, aggravated assault. And that's from April 11th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Now, it looks like the agreement that you've reached is for a 10-year deferred probation fine.
We didn't really discuss fine, Judge.
Typically, there's going to be a fine of $500. I'll look at that at sentencing. Also, part of your agreement, it looks like, is that you're going to enter and successfully complete the cognitive track of the ISF program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Dorsey is not competent?
No.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
Yes, ma'am.
Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for sentencing.
Okay.
Right? You can go back with the bailiff.
Judge, I think we've agreed if it's the court will accept 8 on Mr. Harrison, we can
Yeah.
call him back up.
All right, Kenneth Harrison. Thank you.
Kenneth Harrison.
And so where did I do it on Harrison? Did we go through the whole motion before I stopped and started looking on it? Let me find it. Oh, yeah, we already went through.
I'm pretty sure.
He pled true to 1, 2, 3, 7, 8. Okay, state abandoned. Okay, we're back on the record with Mr. Kenneth Harrison and 24 DCCR 0544. Mr. Harrison had already entered pleas of true to counts 1, 2, 3, 7, and 8. And you guys have visited, I guess, about my unwillingness to accept the plea agreement, and if you come up with some other agreement.
Yes, sure, we have
And what is that?
for 8 years.
And Mr. Harrison, is that your understanding, and is that your agreement?
No.
And so, with everyone's permission, can I make that modification on the agreed punishment
Your Honor,
recommendation?
you said no.
You said no?
Yeah.
Oh, I thought he said yes.
I said yes, ma'am.
He said it.
I heard it wrong.
Sorry about that. It's been scary.
That's okay. So, can I make that modification on this document?
Yes, ma'am.
Okay. So I have here, Mr. Harrison, on the tablet, some documents that have your signature on them. I've made that change to show that the agreement is for 8 years instead of 5. Before you went over and signed these, did you go over them with Mr. Lewis?
No.
Do you fully understand all the documents you signed?
No.
And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harrison is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 7, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. I am making an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or how long that lasts, you can talk with Mr. Lewis. So, Mr. Harrison, in my opinion, you're getting a great deal today. You could have gone to prison today for anywhere between 5 years and up to the rest of your life. And I know you've probably been hearing out of the jail what's been going on with the cases where people have guns and are continuing to use them and possess them. So take advantage of the time that you have, do something better with your life. And when you get out, don't possess a gun. Don't be around anybody that's possessing a gun, because if you are and you're here in Jefferson County, it's going to be a whole lot worse than today. Do you understand?
Yes, ma'am.
All right. Good luck to you. You can go back with the bailiff. You'll get credit for any time you've been in custody. Let's see. What about Jermaine Reddo?
Yes, that one, Judge. Meaning Philip talks like that one.
Do we need him out?
I don't.
Judge, what we did, this is the one, he had new charges that were filed. It was a felon in possession of a firearm and things that you were concerned about. I checked with our intake division. They found they refused those cases based on complaining witness,
Okay.
found them to be unreliable.
Okay.
So what I would propose to do would be to just go on the technical violation, which would be well, it was 2:09 p.m. outside of his residence. He was arrested for this, and it was charges were not filed. So I can either dismiss the motion or we can give him a jail sanction for the time that he's been on.
I mean, obviously, should that be AM? Because being somewhere else at 2:09 PM is not a violation. I mean, if everything was.
It was AM. That was just a typo in the MTRP, but that's the only allegation that we would probably move forward on.
Let's get Mr. Reddo, please. I mean, you can file a motion to dismiss it and I'll sign it, but I want to talk to him real quick before I sign that. I created a new document, but I'm not doing anything with it. There's really nothing to, this is his second. I didn't think last time get dismissed. Well, third, is that the? So on these new offenses, the possession of a firearm allegation, is that something that only that uncooperating witness could prove up, or is that something that law enforcement?
There was a question about whose weapon it was.
Because this is the second MTRP that has to do with.
Well, the first one was dismissed because the only violation allegation was that he possessed a firearm and fell in possession of a firearm, and he had been on deferred, so he wasn't.
Right. And but still shouldn't be possessing a firearm while you're on probation, regardless of that. So, Mr. Reddo, probably what's going to happen today, based on the information that I've received from the district attorney's office, is that motion to revoke your probation is going to be dismissed. This is the second time that you're kind of getting away with doing something that you probably shouldn't. I want you to understand at this point, I'm going to order that you are on zero tolerance on your probation, that you will be on the high medium caseload and required to do everything that you're supposed to be doing. If you are caught with a firearm, if you're around anyone with a firearm, I don't care who it belongs to, ownership, if you're around it, it is going to be a violation of your probation. I'm ordering a condition of your probation is that you are not allowed to be around or in possession of a firearm in any way, not in the same house as one, not in the same car as one, period, none. So there won't be any question if there's an issue that keeps popping up here with regard to firearms, that if you're around one, it won't matter whose it was or whose it belongs to, it's going to be a violation. And it's not going to get dismissed. You're going to end up going to prison. Do you understand? You're on a very serious probation, and I have some concerns about what's going on. But you're back on that probation. You still have the same opportunity to be successful. It's going to be up to you to quit doing whatever it is that's going on. Okay. If you have an issue with whoever it is that you're dating or married, then you need to get away from that, because that's going to end up getting you into trouble. Right? Okay. You can go back with the bailiff. Angela Reyes. What?
And the West, they're being dismissed.
Are these the three she's playing on?
Yes.
Okay. Thank you. That needs to be.
Oh,
Good morning, ma'am. Are you Angela Reyes?
Yes.
And will your client waive the formal reading of the indictment in each case?
She does, she does.
Ms. Reyes, you are Angela Reyes, correct?
Yes, ma'am.
And Ms. Reyes, in cause number 26, DCCR 0265, you're charged with the third-degree felony offense of obstruction or retaliation from December 22nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 26, DCCR 0787, you're charged with a second-degree felony offense of assault on a peace officer. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0788, you're charged with a third-degree felony offense of harassment of a public servant. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes.
In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like the agreements that you've reached in these three cases would be for you to receive 10-year deferred probations in each case. There would be fines in each case of $1,000. You would be ordered to
Your Honor, I'm sorry. I don't know that it was the intent of the state to have a total
Three.
$3,000 fine. I'd be willing to waive the fine on two of those cases and just have.
So a $1,000 fine in, let's just put it in 0265.
Yes.
And there would be no fine in 0787 and 0788. Is that your understanding?
Yes, ma'am.
Is it also your understanding that you would submit to a mental health evaluation and follow any and all recommendations and treatment, be on that mental health caseload at the
Yes.
probation department?
Absolutely.
State tenders number one in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Ms. Reyes is not competent?
No, Judge.
All right, ma'am. In each of these cases, and also part of the agreement is that the state would dismiss all of the other remaining cases. Is that your understanding?
Yes, ma'am.
Then I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation can do a pre-sentence report and possibly get that assessment done or at least partially done so that we know exactly what you need when you are released on probation when we come back for sentencing.
Okay.
Okay, you can go back with the bailiff.
Thank you.
Thanks, sir.
Yeah, I'm trying to find a new human. You know, there's a reason. No, you know, what the contents of it, what the contents of it's an entrance. We'll claim you. All right. Book for all this and was. Now I'm going to. So.
Any cases to dismiss?
Simply. Here. I think.
Yes, and when they have those meetings,
Listen, sure. People that have, I mean, almost live the base.
All right, Jameldrin Wilridge, sentencing.
Marvin. Richard and this is my wife. Dogs.
Just kind of.
Right, are you Jameldrin
Yes.
Wilridge? So we're here. Mr. Wilridge has he's on probation in 3 cases, 18-28743, 28744, and 30139. And then there's a new offense, a burglary of a habitation, in cause number 25, DCCR 1804. And there was an agreement that was reached and he entered a plea of guilty to that burglary of a habitation case. The agreement was for a 10-year deferred probation, restitution to be determined, and that those motions would be dismissed. There was an issue between obviously when he pled and now which required I revoked that bond because he was arrested on May 26th in Chambers County for a 3rd-degree felony and a Class B misdemeanor. So obviously that
kind of nullified from all of our position where we
with that agreement, Judge.
Right.
So you know.
Okay, so where are we? I mean, I'm going to at this time reject the agreement formally, so we can start all over. You guys negotiate whatever y'all want to do. If we need to get more information about that Chambers County case, but obviously I'm not inclined at this point. I see no reason if those allegations are true, that Mr. Woodridge would get another opportunity on 3 felony probations with now the new burglary of habitation here. And while literally days after he entered pleas here, went and was at a minimum in a county that he wasn't supposed to be in without permission and arrested for those offenses. So my thought is, do you have any information on those yet?
No, Judge, because when we broke last night, it was primarily, obviously not knowing that was going to happen in Chambers County for the restitution in the burglary. Because we
Right.
all had the discussion about how could tennis shoes cost that much.
Right.
And I have spoken several times with Mr. Riley, who the court knows is an excellent PSI writer. And he assures me, and through an affidavit from the complainant in that case, that that's what the restitution amount is. So I feel like we could ask for that and see if he'll pay it, and so be it. Then obviously the new offense came up, which then put us all kind of back at square one. The court is aware that I have always been a little bit more outgoing with Mr. Wildridge, wanting to give him an opportunity. I'm not suggesting I still don't want to do that, but I certainly understand the position that we're all in. I mean, the files are just stacking up.
Yeah.
And
I mean,
And Judge, only thing I can say in that regard is that, of course, I've dealt with him for a long time in this situation, and he understands it was inexcusable for what happened in Chambers County. But I will say that it's the first time that since then that he's actually opened up to me as far as asking for the type of help he needs for any underlying issues that may be there. And it's something that his family was actually in the position to try to get started when the whole bond situation occurred. But of course, he turned himself in, did what he's, complied with your orders.
And that, per our conversations, I think, Judge, it's important to note that that has to do with underlying mental health issues that go directly in correlation to his behavior. Although it doesn't excuse his behavior.
no, it
Yes,
doesn't. And I guess, I mean, you guys know, I mean, he's been on probation since 2018.
Right.
There's been every opportunity to take advantage of any help. It's not like he just did all this and we say, okay, well, now let's do this. We've got help for him. It's been years that we've gone through motion to revokes that have been dismissed. And
I mean, the only thing I can say is a lot of times in these type of situations, of course, the help doesn't work unless the person is ready for it. And of course, like I said, this is the first time he's opened up to me as far as trying to get that. And a good thing for him, he does have the support system there that he can try to get that help.
And that's so great. And it's also such a shame at the same time, because I'm guessing he's had the same support the whole time. It's not like people are just now stepping up and saying, let's help him out. Right. I mean, they've been there the whole time. And here we are with our 5th felony in Chambers County while you're on probation for 3 here. Here's what I need. I'm not going to do anything today. I want to find out, see what you guys can find out about Chambers County, what the status of those offenses are. Get Mr. Lewis whatever you can, so that I can also have a little, even if it's just a PC, so I can see a little more about what the underlying offense allegations are. And then we can kind of reconvene and see, I guess, where, if you guys want to try to tell me what some agreement is, I'll see if I'm willing to go along with it or not. Obviously, probation, I value your opinion. And so
More likely than not, Judge, if it's okay with the court, probably will not come to you with any type of agreement, maybe just more of a conversation. Obviously, we're all aware of the situation that all of us are in right now with respect to individuals this age that have been given multiple opportunities and what else going on. So I don't.
We're also going to go through, we can do it. I don't know, there probably needs to be amended motions, on those three.
To add those.
To add those allegations, and I'm not gonna just sign a dismissal on those motions. I want to go through each and every allegation, of the motion, get pleas of true or not true, and then we'll go forward. So between now and then, if you can get, I guess, any type of hearing done so that we can get those new allegations in the hearing, in the, motions to revoke, we'll go through those at the next court date, and then we'll see where we are from there.
You get that.
Okay.
problems with.
All right, thank you. Go back to the bailiff. It looks like it's David Hale. Did we do David? David Hale and Mr. Lewis? No, there's no. You guys haven't reached, there's no agreement on Mr. Hale, correct?
No, Judge, we're gonna be asking for some more time, to be honest with you.
Okay. Good morning, sir. Are you David Hale?
Yes, ma'am.
This is 26 DCCR 0106. Mr. Hale is charged with aggravated robbery. And Mr. Lewis, what is the announcement?
Judge, we'll ask for some additional time. I have spoken with Ms. Morfino about this situation. I understand that the state may be looking to either amend or the charges may change on this, but I do need to speak with them more about his criminal history and everything like that, how that affects him as far as that punishment range.
All right, so I'm going to do one more reset. Obviously, if there's any type of,
Judge, I think the case is more appropriately indicted as an aggravated assault. I asked Mr. Lewis just to speak with the defendant in the hopes that we could resolve something absent having to do that. At the next setting, I need to do that. I can have it done in a week.
okay.
Or I can go ahead and do it.
I'd rather you guys get that figured out before, so we don't have to
Okay.
reset it at that point,
Right.
if possible. So talk with your client, talk with Ms. Malfino, and if that's going to be something that's going to get worked out, if you can do it before the next court date, then
Sure, it doesn't change the punishment range or anything,
Yeah.
obviously, but it makes more sense to the facts, which might make more sense to.
sure. Okay, sounds good. We'll reset it.
Thank you.
All right. Was he in trial? Did he end up in trial? That's right. Mr. Did I just see Mr. Samuel? Lost him?
You've been here, Judge, you just went back.
I know, I just saw him.
He's back here.
It's all right, I'll get, Mr. Macon, you have Aaron Wars, the sentencing.
Yes, sure. Aaron.
He's feeling better. Just had to pronounce the one. We had another one yesterday that was, having a hard time. Yeah. Surely he's, sober and awake today.
He was this morning when I talked to him. He's probably just still tired. I've gone over the probation letter about safety and
Yeah,
he's fine with that.
let's wait for him to get out here. Morning. You are Aaron Wars. Feeling better this week, Mr. Wars? So, Mr. Wars, this is cause number 25 DCCR 1253. Previously, you were in court, entered a plea of guilty to driving while intoxicated, third or more, received that pre-sentence report and reviewed it. Have you both had an opportunity to review that report?
Yes, Judge. Yes, Your Honor.
In addition to that, we received an, We received an update, also a memo from probation, I believe it was yesterday or late last week, and you both had an opportunity to review that as well.
Yes, George. Yes, Your Honor.
And so, any other issues, Mr. Smith? Obviously, based on the issues last week with Mr. Wars testing positive, there's clearly a need for some intensive treatment. Any reason though not to go along with the agreement still?
No, Judge, I think we would amend it because we did not have treatment involved. We would ask for safety placement.
Your Honor, I've gone over with Mr. Wars and he agrees that he needs safety.
Okay. So Mr. Wars, we're going to give you this opportunity today and I hope you take advantage of it. Because if you don't, things could be a whole lot worse. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find, sufficient evidence to find you guilty, and at this time, in accordance with your agreement, find you guilty of driving while intoxicated third or more, sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation. That it will include entering and successfully completing the safety program. And then when you're out, you're going to enter and successfully complete the JCDI program as your aftercare. That will give you a longer period of time with more structure and drug tests and classes and things like that. You're also ordered to serve that 10 days upfront time. It's required by law. You'll be able to serve that while you're waiting to get taken to safety. And then any of the other conditions that probation feels like are necessary. You follow all of these and do everything that you're supposed to. This is a great opportunity because you'll be able to serve this 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you can be brought back into court and you would be facing that 10-year sentence